All right, we are at 12:30. So Heather, if you're okay with it, then I'm going to go ahead and start the just the housekeeping part. Okay.
Great. Sounds
All
good.
right. So first of all, welcome everyone to DMLA's part two in a three-part series on releases. I'm very excited about this one. I think it's so important, and this is such a great group. Let me say a couple of things if I can. Today's session is going to cover places. We have a couple of housekeeping notes. Please enter questions into the chat area or to the Q&A, and I'll be trying to monitor that for the panelists. The webinar is being recorded and it will be made available to our members in the video library. There's been a request that we make this series publicly available, and I think there's a lot of support for that, but we're going to ask our legal committee to consider this. And if we do make it publicly available, we'll let all of the attendees know. At minimum, there'll be an embargo period for members, and we'll probably put some snippets up onto our YouTube channel. We have a wonderful panel today. Three incredibly smart and talented women who I like very much. Heather Cameron from Getty Images, Margaret Vincent from Stocksy, and our own Nancy Wolff, who's DMLA's counsel and a partner at Cowan Debates Abrahams Shepherd. Finally, we need to say that this presentation and the statements being made are the opinions of the participants. They should not be considered legal advice, and they may not necessarily reflect the views of DMLA or its leadership. So that is it for the housekeeping, and Heather, I will turn it over to you.
Thank you. So we love this releases topic so much. We just had to make it into the series. People, places, things. Today we're going to focus on places. Doesn't mean we don't care about things. We love things. We're totally going to get into it. Things involve copyrights and trademarks, but sometimes locations do too. So we're going to kick it off. We love this image to illustrate just this concept because already super famous place. There's artwork going on. There's people. There's like logos. I mean, so many things are happening. What are the rules? But really, at the end of the day, what it comes down to is what are you going to do with this content? And then decide how these different rights matter. This is a repeat, Nancy, from last time. And Margaret, you might want to talk about this. We kind of a little bit reviewed this before, but we thought we'd bring it back just to go over one more time.
So is it I'm doing this or Margaret doing it?
You're going to talk. We're all going to talk about it.
Okay.
Commercial, whatever.
Yeah. So just jump in when you want. When you're, Heather just said, what are you going to do with this material? And there's a lot of things you can do when you're illustrating subjects that's newsworthy or of public interest, whether it's cultural, historical, sports, events, concerts, that you can't do if you're trying to use that image to illustrate a product where you're trying to sell something or promote something, goods and services. So there's a lot more leeway when you're illustrating something newsworthy. And newsworthy could be news articles online, in print, broadcasts, documentaries, textbooks. Essentially, you're illustrating something truthful, and you need to have a connection between the content and the subject matter. It doesn't necessarily have to be exactly of that subject, but there has to be a relationship for you to use it. And in those instances, you don't need as many permissions, because you can imagine if you try to depict a historic news event, you can't stop news in its track and say, excuse me, will you sign this release? I mean, but it's a completely different thing when you want to sell or license photographs that are going to be used part of an ad campaign. If it's, on a label, if it's, something that is promoting someone's goods and services. And I don't know if Margaret wants to add anything.
Well, I would say this would be the bulk of royalty-free content that a lot of us work with is the cleared for commercial use. So we would ensure at Stocksy that everything that comes through is cleared for commercial use as that higher sort of standard of release necessity.
I would say the same. And on the Getty site, if we have it intended for editorial use only, we definitely let you know that that's the rule.
And the reason there's so much freedom for editorial use is the US has a constitution and a First Amendment. And that First Amendment permits the use of images for newsworthy as well as expressive purposes. So speech that is not commercial is protected speech. Speech that is commercial is not as protected. So that's why you need more consents.
Yes.
Also, Nancy, something that I think comes up is this advertorial versus
Ooh.
editorial. Do you want to talk about that a little bit too? Because I
Yes,
know our
yes.
customers confuse that all the time.
Yes, so advertorial is what you would call editorial in disguise. It's an article, but it's really written by the company that's promoting a product or service. And you actually have to put the word advertorial on it. Now, it doesn't mean if you're reading a magazine and you have an article and there's a page next to it where there's an advertisement. That does not make that article commercial, because everyone expects that there will be advertisements interspersed in a magazine. And the same thing with a digital magazine or blog. You will have editorial content, and then next to it, there'll be ads. But they're separate and distinct, and you don't have the assumption because you're reading a newsworthy article and someone's trying to, sell a nice handbag somewhere else on that web page that there's any connection. So that doesn't convert an article from editorial to advertorial, but it's really like, you're reading an article about these great ski boots that are so good for skiing, but then you realize, oh no, it's written by the
Sponsored.
company that made them.
Newsletters to the
So,
CDAS.
so you can't get away with not having the proper releases by calling it advertorial and making it look like an article.
Right. All right. Well, let's talk a little bit about property releases for locations and why do we care? Margaret, why do we care?
We care because our customers care. This is definitely a big ask of our buyers, obviously, particularly in commercial space, as we've just discussed. We know that released content performs better on stock that's available for commercial use. And even I have certainly found, even if you tell them this is all commercially cleared, they will still call and ask about specific locations. It's definitely an area that buyers are very aware of and can get nervous about.
Yeah. Nancy, do you want to walk us through some of these bullets that we've got on this slide?
And why it's so interesting that there's such a need for property releases with property, when if you really peel the onion back, there's not much of a legal basis. However, it just it makes it so much harder to sell, and you'll make so much more money with these pictures as you have them. So if you peel back the onion and you look at, well, why do you have releases for people? Well, people have protection under state right of privacy and publicity laws. Those laws are limited to individuals. The Copyright Act also allows you to take photographs and videos of buildings and architecture that may themselves be protected by copyright if you're standing from a public place. Because when they added architecture as a type of work that can be protected under copyright, what they really meant is if you designed this really interesting building, someone else can't make the same building just like you. But if someone from the street wants to take a street view, that photograph doesn't violate the copyright in the building. Now that's under US law, and we'll get to this later, that there's laws in other countries where modern architecture, even the selling of a photograph for commercial use, could require releases. And then we'll keep this for part 3, but a lot of buildings, because they can't rely on publicity law or copyright, will try to claim that there's some distinctive element of their building that gives them trademark rights, and they start filing things under trademark, which is a fairly weak argument, but because you have to look at the building and it has to be the source of goods. And I always laugh, like when you look up at the Empire State Building, you don't think of Empire State Building Realty Company. You think, oh, that's the building that the Big Eight climbed, But
Exactly.
anyway, so none of these things are perfect, but a combination of aggressive property owners sending aggressive letters causes a lot of friction that no one needs, and ad agencies don't like it. So if you want to sell pictures, you make people happy. It's sort of the reason why everything in Hollywood, even if it's a pencil, gets released, because no one wants a letter.
And
Exactly.
it's a
There's
more
like,
efficient, it's certainly efficient too, to have it all handled, so you're not dealing with fallout later. Sorry, Heather, go ahead.
agree. Oh, and also just, people make stuff up. I mean, they have an allergic reaction. They think it's legal. We spend a lot of time at Getty Images being, listening with our listening ears and listening for understanding, and then explaining why what they think is a legal thing isn't really a legal thing. But we appreciate the concern, and having these releases and all the great metadata that goes around all the circumstances of a photo shoot, all of that goes such a long way at calming people down and keeping things moving. Nobody wants to spend time and money on claims unless they're paying for the excellent legal advice of Nancy Wolff, which is worth it. Nice plug for Nancy. Okay, let's take a look at an actual release, go through it a little bit. And we're going to be on this slide, for a long time. Sorry about that. It's not more interesting. But Nancy, do you want to just at a high level talk about what we think about this amazing document that I'm sure you helped draft?
Sure. Well, not that dissimilar to a model release. You want to have all the elements covered that the owner of the property, and of course you want that owner to be an adult because only adults can contract, are going to grant you very broad rights to use the images that depict the property for all the uses you can imagine you would want for commercial and in the RF model. And you also don't want any claims that actually would not really apply to buildings anyway, but you throw them in because people will use them. So you want a grant of broad rights for all purposes, and that would be advertising, motion, marketing, packaging, etc. And you would like them also to make sure that you could combine that content with other content, because you don't want them to complain that I don't like the text that you put with my image, or I don't like the description. You just basically want to eliminate all complaints. Because in many states, releases are considered contracts. You want to make sure there's some consideration. And if you just say you got consideration, that's good enough. I mean, giving an owner a print or a digital image these days would be sufficient. And you want to make sure that this release is binding on any successor and interest, because the person who owns the property might ultimately sell it someday. We're looking at the Getty Images standard release, which is one that almost everyone would accept, whether, if you're from any different agency. And we're also these days protecting private information, because there's a lot of privacy laws. So if an ad agency would want to see if there was a release, things like someone's name and etc. would be redacted. And of course you want to, assert that you're over 18 when you execute the release. And the most important thing is that you know what release goes with the images. So you want a visual reference, which is why there's a place, just like a model release, where you put a person, some visual reference from the property, because a release easily separated from the digital content. And how do you know what release goes with what property? So it's really important that there is some kind of visual reference. And also a description of the property and a representation, how you own the property, how to contact you. Now, a witness is nice, not always legally required, but what is great about having a witness, if anyone ever brought a claim, you don't have to necessarily verify that that person signed, because there's a second person who witnessed it. Heather and I have had some fun cases about witnesses signing.
That's the same, that you have witnesses watch the signatures and sign at the same time, just to throw on later.
Yeah. It's like extra protection. It doesn't mean it's invalid without it, but it's
cover all your bases.
Makes it more in a sense enforceable because no one can say, oh, that's not my signature. Well, someone else saw you sign it. We've had a few that's not my signature cases when you know it is. So, and that's a good thing about a driver's license because you can see the signature on the driver's license. And if they match, it's very hard for them to say, oh, that's not my driver's license. Or not my signature, I mean.
It wasn't me.
It wasn't me, I didn't do it. So these are all the reasons why ad agencies and commercial users of content like to know there's releases, because it's really buttoned up and every excuse you can think of has really been taken care of in this release.
If I can just jump in from a sales perspective, also, everyone should be aware this is a selling point too. You're protecting the clients. And so it's not just, if something negative happens, it's really, if you've got, property that's released, as I think someone said earlier, it's definitely more valuable, but you can sell it. You can say, you don't have to worry about this.
Yeah, that's got value to buyers for sure.
I agree. So when and where it was shot, description of the style of architecture, perspective, all of that stuff can go in your shoot description. Super helpful. Also, it can help you with your keywording later when you're submitting content to an agency. And I would just like to take a moment, Margaret. I don't know if this happens for you at Stocksy, but it definitely can happen at iStock and Getty Images, where folks are operating under this sort of, maybe 20 years ago, it might have been a great idea to take a really beautiful photo of a lovely location. And maybe it was a super specific location, but it could be generic enough that this could be in Europe, this could be in the US, this could be in Asia. I'm going to keyword all of those because that way I'm going to attract the widest possible audience ever. You know what happens these days? Customers call, hi. How come it says that this was shot in like 25 different territories? I don't understand that. And I really need something that was specifically shot in the US, or sometimes more importantly, I need to know that it wasn't shot in the US.
Exactly.
Or it wasn't shot in France.
Yes. Yep. And that's we definitely see that. And it's something that we are continually educating our contributors about, because you're right. There is this idea of trying to cover all the possible uses. And sometimes you do have an image that could be from any number of places. But there is absolutely a lot of value to a lot of clients in very site specific or location specific content. We actually see it quite a bit as a Canadian co-op. We have Canadian entities who are under a mandate to use, Canadian based content. So it really becomes very important to get those locations correct and have that metadata for those specific locations, because I actually think it can be a stronger selling point than trying to cover everything.
I agree. And when customers call us and they ask us to help them research for projects, if we have any people from our research team watching this webinar right now, they're like, yes, tell them, Heather, tell them to get the keywords right. Be specific. Okay, I'm going to go through, while we're still on this lovely, property release slide, I'm going to give us some frequently asked questions that we hear all the time. And Margaret, I'm going to send the first one to you. Can property owners modify the release in any way?
They cannot. We design these releases and our products and services around this broad grant of rights that's covered here. And this is particularly true with royalty-free content, where you aren't necessarily dictating every detail or limits to the end use. So you need to make sure you have the broad grant of rights so that we can treat all the content as having that same grant of rights. So it's really also ideal to hammer this all out in advance, because then you'll have all your protections in place.
Could not agree more. And our inspection team has been trained, if they see any sections that have been crossed out or something's been written in the margin, no, this is what I mean, it's an instant rejection. Now, there could be some shoot situation where it's going to be the perfect location and somebody's not going to want to sign a standard type of property release for some reason. It's not going to work for them. Well, before a photographer or an agency makes a commitment to fund a shoot in that particular location, make sure you're having a conversation about what that broad grant of rights and how the content can be used. Have those conversations in advance. Make sure that you're talking to the right people at the agencies that you use for your marketplace to make sure they're going to accept it. Why do an expensive shoot if we
And that you
can't
have the right
license it for you?
signer, right? Yeah, don't get a signature that turns out to not be usable
Yeah.
and you've done all this work. I know it can be really sometimes I don't want to say scary, but I guess I'm going to use that word because I can't think of a better one today, to sort of get all these releases in place, especially if you're doing this and you're not used to doing it on the regular. But it really is to your benefit and the agency's benefits and the buyer benefits to iron all these details out up front before you put in the time and energy.
Could not agree more.
Yeah.
Okay, Nancy, next question's for you.
Right.
This
I
comes
just
up
wanted to
quite a
add
bit.
something to
Yep.
that,
Yep.
which is the amount of times there's been claims, whether it's about people or places, it's usually when a photographer tries to downplay what a broad release is. It's like, oh, it's all, you know, we would never
It's
use it for
just for my
that. It's only for
portfolio.
something. It's just,
Yeah.
if you're uncomfortable, just practice, maybe even from the mirror, being confident, but like, no, it, you know, but it's, I only license through these reputable companies and these are the kind of uses, but we need broad rights because you can't control how things are. Just get comfortable asking for it and don't feel embarrassed.
Agreed.
Okay,
Great advice.
Protects
ready
everybody.
for your question.
Okay, Nancy, can a property release be created for a date range instead of securing one release per day when you're shooting in the same location?
Okay, well, that's a good question. I don't think it's invalid because it's an agreement and an agreement can, you know, cover a period of time. But I think the most important thing would be that it clearly covers all the properties you're doing. So I would think that if you're shooting for a few days, but there's different properties, you would probably want a different release for the different properties because what you don't want is any ambiguity at the time. If someone complains, hey, I recognize my villa, my house, my building, my whatever, and you have this one release that covers a few days and the only sort of example you have attached is one building. So if it was maybe one building, I think you wouldn't have an issue because, you know, maybe you want to come back and the lighting's different at different times or something like that, or you had a rain date. So I don't think there would anything about it would invalidate it. I think what you always just want to do is make sure that when the time comes, you can always use that release for that image. And I don't know if you have a different answer than that, but that's what I would think.
I say also put it in the shoot description why there could be that date range. Sometimes you're on a cruise ship and it's not a 3-hour cruise, it's a 5-day cruise.
Right.
And you might be shooting any one of those days, doing a wide variety of activities on the cruise ship. You want to make sure that the cruise ship people have signed off on that. To this day, I still get inquiries from a certain cruise line that shall remain nameless. And they're stunned that we have photos of their cruise ship available for all commercial use. Stunned. And I have to remind them that 24 years ago, they invited our photo studio to do a photo shoot on their cruise ship. And here's the release. And then they're like, oh, right, I forgot. Okay. So just, it's invaluable to make a note of like that. Okay, this is one more for Nancy. If the release property I shoot now changes hands at some point, will my release still be valid? You a little bit hinted at this earlier.
Yeah, it should be because the release says that it's binding on your successors and assigns claiming an interest. I mean, and with a model release, I would have no hesitation answering that question. So I believe contractually it does, but when you're dealing with real property, it's a little bit odd because legally there's actually not a strong basis for it. It's really you know, a protection contract. And there's some people that might argue that, well, maybe you should file it with your deed, but that seems very excessive. And I really have never had anyone, you know, legally fight that one of these are not valid because another person has moved in afterwards. So I think if you move into a house and someone signed a release years before and it's the old picture of the house, I mean, that's what happened and you have to live with it.
Yeah,
I think that's
we
the
definitely
key.
have
The old picture.
The old picture. They can't do new pictures, but the old picture You know, you could never extract older pictures from the library anyway.
Right.
But the language definitely permits it to continue on regardless of the owner. So,
And just speaking from considerable experience, we have definitely had instances where we had to show current homeowners that the developer signed a release at the time the home was built, or a prior owner, signed that release. And that usually like, oh, okay, all right, well, I didn't know that. I'm glad I know now. Every time this image comes up in an ad and my mother-in-law calls me, I'll be like, I know. It was before my time, but thank you so much.
Yeah.
That's why Shoot Records the best. Keep all your stuff. It's great. Okay, moving on. Nancy, tell us a little bit more about consideration. You hinted
well,
on this before.
consideration just means anything of benefit. It doesn't have to be money. It could be $1, and it doesn't have to be measured in value. And it could just be you allow someone to have an image to use. You need it if a release is considered a contract. In some states, releases are just permissions, like New York, and may or may not be needed, but always good in any release to have the person acknowledge they received consideration, because once you acknowledge it, you can't undo it. So it's very helpful in showing that your release is enforceable and they can't terminate it. Because once there's consideration, it cannot be revoked.
Margaret, I don't know
First
if
thing
this
you learn
comes.
about contracts in law school.
The other
All right,
is
go ahead.
that the
true.
property release runs with the land. It stays with the land, not the owner.
Yeah. I just, Margaret, I don't know if this comes up for you, but this has come up certainly for iStock and Getty Images, where a photographer as consideration will make content available to the property owner or tenant who lived there, and they can do what they want with those pictures that they received for consideration in exchange for doing the shoot there. I just need to remind those photographers, if that's true, and you decide one day you are going to use a reputable copyright enforcement service to pursue unauthorized uses on your behalf, and that is nothing that is in sort of a stock agency license history, because it's totally separate. It happened at the time that you created the content. It's separate from us and our distribution channel. Just make sure that you are communicating with that enforcement team. Oh, by the way, don't pursue claims against so-and-so because they are authorized by me.
Yeah. And we do also advise our creators at times to, set some limits on how broad the use is. So like if you come to us and you say, well, I did this photo shoot for this individual who wanted a few photos to be used in this article about them, you can clear the use for the article, but not allow them to sub-license for other, commercial uses or something like that. So that's something we can always encourage. You can't, the agencies don't control that, obviously, but it is something we can encourage folks to do. But you're very right. If you're thinking about enforcement, got to keep that in mind for sure.
Yeah.
Heather, is this a good time to jump in with a question?
Sure.
So Rick Ray has posted the following, and I'm going to read it. You can think about it while I'm reading it. It's
Okay.
relatively easy to get a release from an individual homeowner. However, it's almost impossible to obtain a release from a hospital, a large hotel, a warehouse, a jail, or 1,000 other locations where ownership, management of the building, investors, board of directors, the government, etc., is impossible to ascertain and get to understand, let alone agree on a release. I can't imagine any stock agency has a legitimate release for a hospital. Actually, I know some do.
We sure do.
A hospital or a jail or a hotel. If they do, it's an extreme rarity. Totally agree with that. Thus, it would seem no stock agency that requires location releases for these kinds of properties actually have one to offer a customer. So how do Getty, Stocksy, and others offer this to their customers when any location shot without a release is routinely rejected during the submission process? And as a follow-up, do Getty and Stocksy and Adobe intend to change their policies for submission based on what Nancy has been talking about? Buildings have no rights unless the architecture or logos trademark.
You want me to jump in, Heather?
Sure.
I can certainly speak to Stocksy. We actually have plenty of releases for spaces like hospitals. I don't think we have jails. We could, but it is absolutely possible to get those releases. I actually don't think I would say an extreme rarity. It's not the easiest thing necessarily, but there are certainly a lot of creators who are building relationships with these entities in order to be able to get those releases. It's really, I think, a lot of conversation and like we've talked about, educating the property owner about what's going to be used and how that's going to come up. So yeah, I mean, I think it is possible. It may not be possible for everyone, but it definitely is. And then in terms of would you change your policy? Stocksy actually already, we do allow buildings and external views without, not even if it's certain single buildings, we allow that based on what Nancy was talking about. Heather, do you want to, I don't,
Sure.
Getty
We
may have some
definitely,
differences.
we have so much content that's fully released from hospitals. What I think is so interesting about hospitals is that the photographer can go so far as to get a release from the hospital. They thought it all the way through. And then we are looking at content they submit to us, and they're showing us an x-ray, and then it's got a real patient name and patient number on it, and they forgot to clean that up in post, you know.
Yeah.
Or maybe there's like somebody's getting an IV drip and that has a medical manufacturer loud and clear, and they forgot to clean that up. You know, that's
logos
more
on like a surgical tape. I mean, yeah, there's a lot of logos hidden in those spaces.
right. But there are so many that actually are released because the photographer has to plan it. They have to set space aside. Oftentimes like a hospital could be incentivized, like, oh, wow, we're going to get some free content for our marketing out of this. There could be a barter arrangement that goes into that. It's not always that you're, paying money to a specific location, but absolutely it is possible. And there are so many examples on Getty Images and iStock. Just sort of take a look and maybe find some of those photographers and say, how do you do this? Because you're amazing, because they are.
And I see there's
and then
comment in the chat that was talking about establishing shots, not lifestyle shots inside hospitals. Same thing. I mean, you're right. We wouldn't be able to offer this sort of content to our clients safely without releases. So we really, we make sure we have them.
Yeah, if you have an outside shot of a hospital and you have the hospital name, it's not a great idea, because you know what? The hospital's going to call and they're going to be like, I don't want to be associated with this drug that kills people. Why are you putting my hospital with that? But if it's a generic looking building, it was shot from the street, we'd probably take it too.
A view that sort of is more generic. Maybe it's just an ambulance bay with no defining, characteristics. Yeah, that is a way. I think, I hate to, as a lawyer, talk about getting around releases, but there are certainly ways to come at a property and sort of work to limit the specific details, and that can help.
So just a time check. We've got about 26 minutes left, although we did extend it if anyone wants to stay.
Okay, we're going to keep it moving. We're going to move on to exteriors and interiors, if that's all right.
Let's do it.
Okay, Nancy, what do you think? Exterior shot from the street? They're not really trespassing, right?
Heather, I don't think your presentation is showing. Is it just on mine?
I can see it.
Oh, you
I'm sharing.
Okay, somehow it's just on mine. Keep going.
Okay. So
Well,
Nancy,
okay, you're not trespassing if you're taking a shot from the street. I would say, as a practical matter, if a house is kind of unique, well, and maybe this color combination and shape, maybe that if you want to use it for commercial use, you may want to get a release, because this is something that the homeowner might recognize, versus a more cookie cutter house in a development where they all look the same. But you're not trespassing if you take something from the street. And if this was some kind of architectural marvel under Section 120 of the Copyright Act, you could take a picture of it from the street. Definitely, if you're going inside a house, you need to be invited in. And that would be trespassing if you just walk through that open door.
And Nancy, too, when you're shooting inside a house, and we love property releases for interiors for sure, to make sure that our photographer was permitted to be in space and time to get that shot. So do you want to talk about what else to think about when you're inside?
Well, this will give a little prelude to the part 3, but when you're inside a house, you have to be aware of the types of objects, paintings, works that give someone's home a lot of character, but could have ownership by other third parties. So there
And
could be original
photographs
paintings or
of
photographs,
people that would then
sculpture,
trigger
right.
model
pictures,
release fees
yeah,
as well. Yep.
family photos, those kind of things. Or, you know, don't have a television on. Or if you're doing video, don't have a radio in the background playing where you might have music. So any kind of thing that could have third-party rights, you want to be careful of when you're doing interiors, and make adjustments for that.
Yeah. Speaking from claims experience, I can tell you that we often get, you know, we talked a little bit about this in the first webinar with mistaken identity model claims. We also get mistaken property claims. Somebody, that's the pool in my backyard. That's the dock at my lake house. That's my backyard. And how did you get in there? And it's so great because super quickly we can take a look at that property release, know exactly when and where that shoot took place, and easily answer, you know, more questions and let a claimant know this really isn't a thing, and here's why. We're always respectful. But speaking of that, though, sometimes, Margaret, I know that our photographers think it's a great idea to get a short-term rental like VRBO or Airbnb, for example, and do a shoot there. Does that come up for you?
It does indeed, and pretty regularly. It's really important to remember the difference between sort of short-term and long-term rental spaces. So if you're in an Airbnb or a Vrbo, you know, space, keep in mind that you're in someone else's space, right? It's their objects. They've set that space, that home. In that case, you would need that homeowner or space owner to sign a property release. It's a little different. I always use the example of my own apartment in the building to sort of speak to longer term rentals, which would be like my property is in my apartment space. So I can release my specific apartment, but that doesn't give me the right to release, say, the building lobby or the lounge. So that's something to keep in mind. But yeah, with those short-term rentals, be really careful. It is not a free and clear released space for you to use. Another thing that sometimes has come up is people think that because there are images of these spaces on the, you know, Airbnb site, that there is sort of an ongoing right to use images in that way. That's really not the case. Airbnb couldn't license those images for commercial use, nor can anyone else without getting the required grant of rights to do so. So definitely watch those homes and talk to your Airbnb hosts and see what you can do beforehand.
I love it. Okay, I'm going to keep it moving. In the interest of time, iconic buildings and signage. Nancy, this comes up so much.
These are fun ones. And this is another precursor to the next one.
Yep.
Because you know, buildings don't have copyright protection, iconic buildings will register with the trademark office a particular element that they think is a source identifier. For example, the Empire State Building has line drawings at the top of the building. Hollywood has trademarked their sign. Radio City has the neon, and Wall Street has the front columns that you're facing when you're looking straight at it as a trademark. Now, trademarks are different from copyrights, and we'll get into that more next time, and that all reproductions are not a trademark use. So you can use any type of geographic image as a geographic locator, because when people look at it, say it's a travel brochure or something, they're going to not think of the owner of the building, but they're going to think, oh, this means you're in, you know, the financial district. this means you're in, you know, the part of California where all the movie stars live, or so
Exactly.
there are very legitimate reasons that you can use buildings, even though they may have an element of them trademark. Be careful of Disney because you have a ticket when you get in, and we'll get into that more.
Yeah.
But trademarks and copyrights are very different, and you can always accurately describe a place as where it is. And there's also something called nominative fair use in trademarks, but we'll save a lot of that for next time. And
Do you want to talk about this one,
yeah,
Nancy?
so
or do
this
you-
is the case that really brought a lot of things to light when the Rock and Roll Hall of Fame Museum opened in Cleveland. It was a unique architectural design, and there were a lot of photographs of it. And the building, the owners of the building sued a photographer for selling posters of the Rock and Roll Hall of Fame at sunset. And the court came back and said, well, a building doesn't really serve as a trademark well, because what angle is it, and from what direction? And it's always legitimate to accurately describe the subject matter of a property when you name it as a, you know, as a poster, a print, a work of art, any type of description like that. So they said that the building wasn't serving a trademark use, which was very helpful in trying to explain when people recognize their building and see it in, you know, reproduced somewhere, about why it's not being used in a trademark manner. Now, if you were someone trying to have an association, like let's say that you were a cleaning company, you're like, oh, and we clean for the Rock and Roll Hall of Fame, and they use this picture, and you have some contract that says you're not allowed to do that, that might be different. But if you wanted to sell a poster, a limited edition print of the Rock and Roll Hall of Fame, and identify it as the Rock and Roll Hall of Fame, you could. So that gave a lot of guidance for things like when the Hollywood sign sends a letter, or the New York Public Library sends a letter, or the Empire State Building sends a letter. The other thing is when they're all in a skyline, you're not going to identify any one building, so that's okay too. But we're going to talk a lot more about that in session
Part 3.
This is just
Okay.
a
Speaking of New York and iconic places in New York City, so can this image be licensed without releases of all of these different buildings and marquees and things? Could it be licensed for commercial use? And I say yes. And I
yes.
say yes because no one sign or location is the sole focus. There's safety in numbers with a situation like this.
That's
Piccadilly
true.
Circus is the same.
Yeah.
So many brands and marquees. But I have to say, under the Getty
There's a
Images
little
and
asterisk there though, Heather, right?
licenses, yeah, if you were to crop in on one specific sign or one specific logo, a customer can risk losing their identification because they violated our content license agreement. Making those modifications, we're guaranteeing the photo as it leaves our website and beams to you over the interwebs. But the minute you make those alterations, maybe you don't get a Heather Cameron with every license.
Yeah, I would agree with you. So for example, if you were using this picture to promote a tour of New York, no one who looked at this picture would think that this tour was, say, sponsored by Sephora, because it's just one of so many different billboards, promotions that are in Times Square. You have, you know, a building with H&M on it. You have all the Broadway shows. You have Century 21. And I guess you can
Disney
sort of
and all of them.
even a piece of Disney there, right?
Right.
So Marriott Marquis, it's because trademarks aren't violated when you reproduce the trademark. They're violated when someone could have an improper association or affiliation.
Right.
And when you have so many, they all sort of cancel each other out, because you can't say any one of them would be the one that would be promoting it, because there's too many in there. And that's the safety in numbers.
And everyone on this call from Stocksy will know that I use that. I talk about that with grocery stores all the time, but that's also for things.
I love it.
Safety in numbers for sure, though. Yeah.
Okay, Nancy, what about these painted ladies? These homeowners have had thoughts and feelings.
Right. So if anyone's been to San Francisco, there's a a street where all the Victorian houses are painted in different colors, and everyone probably comes there because you can get such great pictures. And they actually brought, and I don't even remember who claimed that they owned it. I don't know if they have a homeowners association. I don't know. But a claim was made against a company that used a picture of the painted ladies for commercial use. And it was one of the first cases, and it's still a lower court case in California, where the judge actually went through all the potential claims you could make when complaining that pictures containing property were used without consent. So the court looked at it and said, well, California has really strong right of privacy and publicity laws, both common law and statutory, but they all relate to people. So that doesn't apply here. And then they looked at trademark. We're like, well, a street of buildings doesn't serve as a trademark, so we can't rely on trademark law. There's no contract. And they went through all the sort of expectations where you could try to, build a claim, like why you couldn't take a picture of these buildings and use it commercially. You haven't trespassed. It's from the street. So you didn't really violate any of the owner's legal rights. And that was, sort of always been helpful, this case, for teaching that, if you really do unpeel the onion, there's not a lot of there, but also a lesson that this company who used this image had to fight a lawsuit to get there. So
Yeah.
it's, again, you'll probably
No
be
fun.
very hard to get an entire block to sign. So particularly when you have so many houses in a row in an area, it's also a geographic locator. You're in a particular district in San Francisco, that the risk is much less if you were to have a customer want to use a picture like that. Because sometimes you'll have a lot of images that says they're not released, and the customer, under most contracts, has to decide whether it's okay to use that or not. And you can see you have the entire sort of skyline behind it as well. And none of those buildings, again, could have a claim that you're using it because there's so many buildings in it.
Right.
We do have another question specifically around this. Do protections apply to gated private neighborhoods? Like in the example given as 17-mile drive in Pebble Beach.
Oh, the Lone Cypress.
The Lone
Nancy, we
Cypress.
can't get away from it.
Never get away from that. Do you want to take the attraction things well, we didn't do that yet. A gated community potentially might have a trespass claim. The problem with the trespass claim, speaking right today, is that trespass is the photographer who takes it. But if an image comes from an image library, the image library never trespassed, and
Right.
there's nothing about the photo that violated. So you don't really have a trespass claim.
But that drive and the golf
Pebble
courses,
Beach,
those are
yeah.
all private property, for profit. You have to pay to play.
Yeah.
All of those places, be careful about, do your
Right.
homework about what their shoot policies are, because they will come for you.
Right. And Pebble Beach isn't trespass. Pebble Beach is the fact that at one time the golf course registered an illustration of the lone cypress tree as a trademark. And then they took a position that every photograph that contained the cypress tree, even if it was, created in the day of Ansel Adams, violated their trademark. And if you look at it, it's not a photograph of the tree is not the same thing as an illustration, and it doesn't serve as a trademark use. And I still remember a former icon in the stock photo industry, Jane Kinney, saying something like, the U.S. Trademark Office is not an arboretum, because in order to have a trademark, you have to have a deposit of the mark. And all they had was the illustration, and no one is dragging trees into the trademark office. So
Right.
A lot of people have sort of an expansive idea of what a trademark can protect, but, again, they're the squeaky wheel. And I think they, for a time, were such an annoyance and caused so much friction that people just hesitate at licensing pictures that include the lone cypress tree,
Right. But you just have
regardless
to
of
think
whether they
about
could
the
or
end
not.
user. That's our job. We have to, Margaret and I for sure have to think about the end user and that experience. And what if they're in an industry or space that directly competes with that particular trademark owner? Does that make it
Another
confusing?
golf course.
Another, yeah, I mean, like awkward.
Well,
I mean, it could get awkward, and then there's
Do we
ways
have
to
two?
avoid that.
Sorry. Do we have two more questions? One is a follow-up on the painted ladies. Would a stock site
Yeah.
list painted ladies as a commercial image?
Absolutely.
Hmm.
Yep.
Yep.
Absolutely commercially cleared based on that lawsuit that Nancy was talking about. Yep.
Yep.
And then a second question, what about restricted locations in general, like animal reserves and maybe need permission to be there? If permission is granted to be there, is a property release still needed?
Yes.
Often, yes.
Yeah.
I'd
So
say
the grant to enter a space is different than the grant to allow for use of the content. Yeah.
Yep.
And then Heather, I think, are you all still going? There was a question earlier that I pushed off about the Eiffel Tower. So I just want to make
Oh,
sure.
we're gonna get there. We're gonna
Okay.
get there with international considerations in a moment. Nancy, do you want to talk really fast about architecture?
Okay, yes, architecture can be protected by copyright, particularly modern architecture. Like, for example, the Louvre is very old, so that's not protected by copyright, but the I Am Pi triangle is still protected by copyright. And in some countries, you can take photos of modern architecture for editorial use, and you may be required to have some attribution, but not for commercial use. So you have to really understand the laws of different countries. There's also things like right of panorama in some countries that are not in the US. You know, typically old churches and historic sites are not protected by copyright, but there could be some cultural heritage laws that might control. And then if you look at the top one, that's, you know, obviously when you look at something that's very modern, you're going to have to look at the rules in the country where it was created, which makes things, you know, a little challenging sometimes. Like if you look at this picture of this old estate, clearly it would not be protected by copyright, but the land itself and the property itself may have some protections that are outside of copyright law and trademark law, and they have protection under cultural heritage laws. And you have to sort of know all these little nuances, which many photo agencies have been collecting for everyone's ability to check before you spend a lot of money doing a commercial shoot.
Yeah, national trust, chateaus, castles,
Yep.
you know, private property, and you know, definitely research locations before you invest to go somewhere
Absolutely.
and shoot.
Check those websites.
Yep. Okay, keeping it moving are these public domain? This comes up a lot. There's this assumption that anything in Washington, D.C. must have been created by the U.S. government. And because it's created by the U.S. government, surely it must be public domain. Well, I have to tell you, there are places in Washington, D.C. There are monuments that are protected by copyright where that copyright has not been given to the public. The MLKJ Memorial is one of those. The National Cathedral is in the center. Just because it's the National Cathedral doesn't mean it's not a privately held church that's not owned by the U.S. government. And there's artwork, very famous artwork by Frederick Hart, the Ex Nihilo relief that is there at the image to the right. And I don't know if anybody is as old as me and remembers the Devil's Own movie with Al Pacino and Keanu Reeves, but there was a moment in that movie where that art sculpture kind of comes to life behind Al Pacino and is swirling. And I have to tell you, the estate of that artist did not like it. That needed a specific release to be used. So just same assumptions can get made about state parks or national parks. Just research, just do your research.
Yeah,
Check
and
photo policies on websites. They're usually there. They're usually pretty detailed when they exist.
Yep.
yeah, and DC is particularly difficult because there is something that the US government, if the government owns something, it's not protected by copyright under our Copyright Act, but the US government can acquire things or have things licensed to them. So the Roosevelt Memorial is still owned by the artist. But there are some monuments that are owned by the government and some are not. And that's why DC has been so problematic.
We also have a question. How do you know if something's actually in the public domain?
You do some research.
Yeah, it won't be labeled, but if you know that it was acquired by the US government without a license, it's public domain. And I think just researching it.
And there are some good lists out there
Yep.
from reputable like university sources that speak to some of those dates and things around public domain.
Yeah.
But yeah.
And I think we'll get to some tools that DMLA offers too, but real quick, there's another question. Are state federal road signs public domain, such as highway signs?
Highway signs would not have copyright protection.
They're not created.
They're too short, they're not creative. And a lot of them are, are international highway standards. So anyone driving knows, what they mean. So,
Right.
yeah.
But other signs, like our friends at the Metro Transit Authority, for example, subway signs and train symbols and things, yes, those can have
Like
trademark
welcome to
protection.
wherever sign with artistic elements could then
Right.
come into play because you get to add those creative elements and you get copyright in.
Yep. Okay,
Heather, I
Nancy.
forgot the Eiffel Tower, so I want to make sure.
Yeah.
Oh,
Everybody's favorite.
So Nancy, do you want to talk about some of these international moments?
yeah. So the Eiffel Tower at night is such a challenge because the Eiffel Tower itself as a structure is in the public domain. Public domain means out of copyright. However, the light show is not out of copyright. So anything at night that has the light show, you have to get consent. And I had clients learn the hard way when they've licensed pictures for a calendar and every picture has the Eiffel Tower at night.
Yeah.
And you would think a light show would have to have moments where it's blinking and not be fixed, but nope, fixed pictures, motion pictures are all protected.
And part of their copyright too is how they lit the tower. So
Yeah.
how it's lit from dusk to dawn, separate from the hourly light show or special occasion lighting design. It's just it being lit at night.
And this is why you get the broad rule of
Yeah.
no night Eiffel Tower.
Right.
Yeah.
Yeah. These ones are definitely shot. All of these were shot for the news. None of these was shot for commercial.
Right. If you could,
stock.
right. So you could still do something editorially, I believe,
Mhm.
Right.
but not commercially. And I
Yep.
could even I don't even want to feel that confident about that.
Right.
Well, and I'll tell you, we have a set of unreleased or of released Uluru for commercial use, which is kind of unheard of. And I
Yes.
have to remind myself on the regular that it is actually commercially released. When I
Yeah.
see
They'll
So
give
Heather,
a permit
why
to
don't
shoot
you
there.
talk about David?
Well, the David is so interesting because the sculpture itself is no longer under any kind of copyright. It predates all of that. But the Italian Ministry of Culture, this is just one of multiple types of properties that are very important to the cultural heritage of Italy, and use inside Italy may require, special permission from the ministry to be used. So this is just something to be very thoughtful about as people are planning. Sometimes, we have photographers that plan their summer vacation. That can also be a tax write-off, if they can shoot while they're at a specific spot. Just make sure you're doing the lay of the land with these different locations. Uluru is also really important because you do need a permit to shoot there, but they also require clearances for commercial uses. So
and it's a
what Margaret
cultural
was just talking
respect,
about.
right? We
Right.
want to we want to make sure that we're respecting the cultures that we are creating in, and respecting artists' work too. I mean, that's sort of it can be annoying about the light show and the Eiffel Tower, but that is it's creative work that someone did, and they deserve the same protections that I get when I take a photo. So yeah.
Right. I know we're running out of time, but just really quickly, because we're talking about international things,
Yep.
it's my moment to remind everybody who can hear me, be very thoughtful about the Olympics. The Olympics is an amazing international event. Different cities are chosen. And we start seeing at iStock and Getty Images, people try and think, Paris 2024. I'm going to take a bunch of croissants and make the Olympic rings. I'm going to, they sort of start thinking about how to create content that's sort of generating the excitement about the Olympics. And I can just let you know, the Olympics, not a fan. They don't like that. They are very much the governing body that says these are for editorial use only. Please don't, recreate our trademarks and
that's the rings.
Well, the Olympics are more than a trademark. They actually in the
Right.
US have special laws that apply to them. They're even outside of trademark law.
Right.
So be
Very true.
careful, even with being creative. Like I've seen pictures, they start really policing stock sites before an Olympics. I've seen
Yep.
like bowls of Cheerios with Olympic rings. All that will get a complaint letter.
Yep, that's
Yeah.
true. Okay, we're going to blow through events and attractions.
Yep, I'll go real
Margaret,
quick.
take us.
So essentially the thing to look for, this is, we're talking theme parks, sporting events, concerts, zoos, museums. Pretty much if you have to buy a ticket or get a ticket to enter, you have to watch for those photo and video policies. If you have to pay admission, get permission. That's there's perfect slogan to remember. Essentially, yeah, these are places you can have rules based on your ticket. Again, like I've said a few times, check websites, especially museums, zoos, those sorts of things for photo policies. They will tell you what is and is not allowed and usually refer to commercial versus personal. And sporting events and concerts are generally a pretty tough option for stock anyway. There's so many IP rights involved, and with video it's even more so. And I say this as someone who actually sells photo of a blurred stadium, but that's about all I could do in the stadium for that respect. But we sometimes hear frustrations around aquarium and zoo refusals, but as in like it's a zoo, everybody's zoos look the same, but we do know in particular, like the folks at the San Diego Zoo, they know exactly what was on their premises and not, and will raise it. So if there's a ticket, definitely look and make sure you have the right permissions before you license.
So that's definitely golden rule for stock. And then on the editorial side, if you are a photo agency like Getty Images and you're shooting for the news, you definitely get a credential with your photo position, and that credential dictates exactly what can happen with that content. Also dictates oftentimes where you can be. So if you have a credential to shoot in the front of the stage, and you can shoot those first 3 songs, and you somehow figure out a way to get backstage and you start shooting, you might be violating your credential. We would never do that. No, we know what we're about and what we're limited to doing, but it's just great to sort of keep all of these different things in mind about how do you get access to these events, how do you be respectful at these events and follow all of those rules so that customers using content later don't get a call from the folks at the Met Gala, how did you get that photo? Not acceptable.
Yep.
Trespassing and other perils. I don't even know if we have time, but these things come up. I was going to tell you about the time that our award-winning journalist Mario Tama was getting arrested for trespassing a year after Hurricane Katrina because he was trying to recreate what happened a year before and get the exact same perspective a year later. And in some instances, entire buildings are gone and he's just standing, on a piece of grass taking a photo. But then, whoop, 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 police show up and want to book him because a homeowner was alerted, hey, there's this rando in your yard taking pictures. And there was so much sadness with people, coming in to be looky-loos in the 9th Ward, not being respectful about what happened in that community. Once the homeowner was made aware, oh, you're actually shooting for the news and you're bringing light to this situation. Okay, we're not going to press charges. Go ahead and go. But that's just an example. Know where you are standing and do you have permission to be in space and time to get that shot. And then the second one is a photo from MoMA in New York. There's going to be some people rolling their eyes at Getty Images hearing me talk about this story, but you can't go into an amazing museum like MoMA and then send Getty Images or iStock or Stocksy photos that say things like New York loft, empty New York office space. No, and that actually happened, and an image was licensed by a company that does window treatments. They had a whole brochure campaign. Some person that works at MoMA saw it and was like, what? We have a very strict photo policy. Nobody should be taking photos like this and licensing them for commercial use. No, we don't like it. So we're like, can we pay you some money in a settlement so that customer can continue to use this one image for that specific use? And MoMA's like, no, we have plenty of money. We don't want your money. We don't want you doing stuff like that. So we had to pay to reprint the customer's brochures, which was not inexpensive to do. We did it because it was the right thing to do to make MoMA happy. Again, if you're a photographer, don't game where you're shooting.
I'd say this is another example of why you have to be honest and realistic and real about what your content is.
Real quick,
Exactly.
we've lost a couple of people, so I just want to say for anyone who has to leave before, if the panel is willing to stay, we've got until 45 after the
Yes,
hour.
We are right at the end. We
and-
only have a couple more slides.
Okay, and just for the attendees, this is being recorded, so if you have to leave, you can come back and watch the end. Okay, go.
So we've been talking a lot about all the things you need to learn about and research. We wanted to give you some resources as well. Digital Media Licensing Association, who we all know and love, has access on their page to a number of the known image restriction lists that exist. So there's a Getty, the Getty's intellectual property wiki, and then Adobe, Easy and Shutterstock known image restriction lists. Check them out. Some of them have some different information across them. Certain things are listed on some and not others. I often will search on Getty and see if it falls under editorial or commercial if I'm really stuck. There are ways to just do that research. So we want to make sure you had access to all of those tools.
And then Nancy, bring us home.
All
Talk to us
right,
about
so-
best practices.
If you don't want me in your life, this is what you do. Do research, do your homework, check if the property, if it's really unique looking, if there's any issues, look at that known restrictions list. And that known restrictions like has a caveat. Sometimes people say they have rights and they really don't, but we will list them there just because we know they are problems. And
Right.
you know, we are looking for a frictionless transaction world, so just to stay away from it. If you have a ticket, pay admission, get permission, keep your records, keep your location, keep your information, check out our
Every release.
resources, and keep coming back.
And we'll
That's
be
it.
back on part 3.
So thank you, ladies. This was very informative, and another plug for the page on the DMLA website. You can scroll to the bottom and the known image restrictions link is at the bottom. And it'll take you right there, or if you have a copy of what was just up. Thank you all. We really appreciate the time. We've had 2 of 3. We're going to have a third. I don't think a date has been set yet for the third, but we will keep everyone posted.
We're
So,
gathering our stories.
Okay.
yes.
Right.
Thank you all.
All right. Bye, everyone.
Thank
Bye.
you.
Bye.